Hello, everyone, and welcome back to the Universary. Today we have a case out of Thurston County, Washington, before Judge Pro Tem Schumacher. We have Shirley Bloom, who is a local attorney in Washington, versus Amazon. Now, I thought this was really interesting, but the one part that kind of caught me was how Miss Attorney Bloom didn't know that she would need to provide evidence of her hourly wage, or just neglected to do that. I just found it a little surprising that a professional attorney would not realize that they would need to prove each and every element of their case when they are wanting to be paid dollars for those elements. So, that was my thought. Tell me yours in the comments. I hope you enjoy.
This report is now in session. Pro Tem Schumacher presiding.
Good morning.
Good morning, Your Honor.
All right, this is Shirley Bloom versus Amazon, small claims case number 37140. And who do we have present from Amazon?
Hi, I'm Lily Alamayu from Amazon.
Okay, and then Ms. Bloom, I see you're present and everyone is present via Zoom.
Yes, Your Honor.
Ms. Bloom, you can hear me? Okay. All right, so I'll start with you. I have your petition plus all of your exhibits A through E. And then I have a witness, Adam Jones, that you may or may not wish to call. Is he here today?
He is, Your Honor, but I don't need to call him, as Amazon's documents clearly indicate their driver damaged the light. So I think we didn't know that until those documents were submitted to the court. Okay. So I think liability is not an issue. I think it's just damages.
Okay. All right. So you're asking for $374.30. The breakdown of that is the $105 in labor, the $224.36 in the light, $16.89 in shipping, $28.05 tax. Are you asking also for the $50 filing fee?
I'm asking for additional funds, Your Honor. I'm asking for wage loss and inconvenience, compensation for inconvenience, which is allowed in a tort case, and of course the service and filing fees. The service and filing fees total $762.40. As you can see by the documents submitted, I think by both parties, we served Amazon both in Olympia and in Seattle, because there's over 120 Amazon corporations listed in Washington.
All right, hold on just 1 second.
I'm sorry.
That's all right. So did you submit any paperwork for wage loss or for cost of service of process?
Yeah, not wage loss, no, Your Honor. Service of process, yes, I submitted the two receipts. That is our service invoices under Exhibit D.
Okay, let me see if I missed those. I thought I had. Oh, I see. Okay, service outside 229, and then the 107. Okay, so you're asking for the 107.10, the 229, the $50 in the filing fee, and then what is the basis for the wage loss, and what proof do you have of the wage loss?
The wage loss is based upon the time it has taken me to out of my workday to deal with this matter. It's been 6 months. This incident happened 6 months ago. And as I stated earlier, up until the time that Amazon submitted documents to the court, they were not indicating that they were liable. So it took me time to do that. I'm self-employed, so I don't have a time slip per se, but I bill out at $400 an hour. And it's taken me well over probably 10 hours, not only the court time, both in January and today, and the time to just deal with this matter with Amazon prior to filing suit, and then when Amazon refused to pay for the damages, etc. It's taken me well over 10 hours to deal with this. I'm asking for 5 hours of compensation of time to be conservative at $400 an hour, because it has taken out of my day, and I'm entitled to that under tort law as lost income and lost opportunities of income. I'm also going to be asking for inconvenience. Non-economic damages are also awarded in tort cases where the defendant refuses to accept responsibility for the damages that they caused, and the inconvenience under RCW 56.250-1-B, excuse me, are compensable. This has been a huge inconvenience for
What are
me to
you
deal with
asking
this.
for? What monetary value?
$2,500 for inconvenience, loss of activities, and
Okay, so
personal
your total
pursuits.
claim now that you're asking the court to award you is $374.30, which looks like it was already paid. Is that correct?
No, that's not correct. Amazon has not paid anything.
Okay, they submitted something that looked like that, so I'll get to that. But it looks like they have an invoice, so you have not, they submitted an invoice to you, but you have not received that money?
That is correct. I've never
Okay,
received
so
any
the
invoice.
$374.30, $50 filing fee, $107.10 service of process, $229 service of process, $2,000 lost wages, $2,500 inconvenience.
Yes, to be technical, the service fee or the filing fee is $52.
Okay, great, thank you. I thought it was 50. All right, and now I'll hear from Amazon. First, I have a question with regard to the payment. I do see an invoice for the $374.30. Is that a check that gets mailed? Has that been paid? What's the status of that?
Yeah, so we sent out, the plaintiff filed a claim with ARC, which handles these types of claims for Amazon. ARC issued a check for $300 on November 8th, 2023 for the payment of the claim once the plaintiff provided us with the repair estimate of $374.30. The reason for the difference in cost is because the plaintiff's estimate for the light is valued at $224. And ARC was able to find a light available specifically on Amazon, the same light for $159. So that came up to a total of $300 using the plaintiff's estimate for labor costs. We issued that check in, as I stated, November 8th, 2023, and the proof of that check being issued and mailed to the plaintiff's address is in our exhibits, as you alluded to.
It hasn't been
All right,
cashed, Your Honor. It was never received.
Miss Bloom, I was gonna ask you a question, but I didn't hear what you said. What did you say, Miss Bloom?
The check was never received, whether they issued it or not. It wasn't received.
Okay.
It was never
All right,
accepted.
so the check was never received. Amazon, do you have proof that it was cashed? Miss,
No.
and I'm sorry, I'm calling you Amazon. That's very rude of me. I'm gonna try your last name. What is it?
It's Alamayu.
Alamayu. Miss Alamayu, do you have any proof that that check was cashed?
No, we're not aware of whether or not the check was cashed. We just know that it was sent to the plaintiff's proper address on
Okay.
November 8th, 2023, in order to resolve the claim that she brought against ARC.
All right, and that address is 79, is that correct?
That's correct.
Okay, and then Miss Bloom, you said the check came, but you didn't accept it, or you have no idea if it even arrived?
It never arrived.
Okay.
I've never seen a check. I've never seen it. Never received any correspondence from Amazon.
Okay.
Actually, I take that back. I received the exhibits to this hearing last week.
Sure. And which light was actually installed? I'm assuming the property's been repaired. Was it the light that you paid the $224 for that was installed?
Yes, Your Honor, because as you can see by the exhibits, Amazon came up with a light that looks like the one I use, but it's not the light that I use. You look at the picture of the light that was
Oh,
damaged.
it's fine. I just want to know which one went in the ground. It's the
This-
$224.36.
Correct. We paid our irrigation guy. We've paid him that much. That invoice has been paid.
All right. Anything else from Miss Alamayu?
Yes, I'd like to address the additional damages that the plaintiff's tacking onto her complaint. So the original complaint, as filed and served on Amazon, is for $374.30. It doesn't have any additional wage loss listed on the complaint, doesn't have any damages concerning inconvenience. The plaintiff can't just show up here and ask for $4,500 more than was ever requested on the complaint. Or ever mentioned to Amazon prior to this date. That's not something that we should be held liable for, as it was not a part of the original filing. And in addition, she says that the main contention here is that we've been trying to settle this matter with her, but she wants us to cover both service attempts, which Amazon doesn't feel that we're liable for. So we submitted her service attempts. The first service attempt says that service was received by Amazon on the first instance. The second service attempt was completed unnecessarily, and Amazon should not be asked to cover that cost. It says in Defendant's Exhibit 5 that Amazon was served on November 13th, 2023 at 11:10 a.m. to our registered agent at 300 DeSchultz Way in Tumwater, Thurston County. And it says that personal service was completed and correct and was left with the agent there. And then for some reason, the plaintiff then tried to complete service again on Amazon over a week later on November 22nd, 2023 at a separate Amazon location and was not successful in completing service. We shouldn't be held liable for the plaintiff serving Amazon again when they already correctly served Amazon the first time. So we should only be responsible for the service fees related to the completed service.
And the completed service, which was done on November 13th at 11 a.m. in Tumwater, is that the $107 service within Thurston?
I believe so, yes.
And then the second attempted service, which was failed, was at a location outside of Thurston County.
Yes, it was at 410 Terry Avenue North in Seattle, and it says that it was unable to be completed at that time, but they had already served Amazon 10 days prior to that. So it's unclear why they decided to serve Amazon again at a separate location and were unsuccessful, but nevertheless, we should not be held liable for those costs.
And then on defense exhibit, I think it's exhibit A, there's a service on Amazon.com paper that you've submitted, which basically, where does that come from, or how did you come about that? Is that something that's on your website where it says service of Amazon will be at the Tumwater location?
Sorry, what are you referring to? I don't see that.
Exhibit A on, says exhibit A, but let me take a look here. It's after the notice. So I think it's part of where the declaration, plaintiff's exhibit 5, declaration of service, the second page, or at least I have an exhibit A.
Or maybe those are plaintiff's exhibits. Amazon's exhibits are numerical.
Oh, I see. It's put in the wrong pile. Got it. Okay, this goes over here. So then, Miss Bloom, where did you get that service on Amazon.com, exhibit A?
From the service in Seattle, and it is attached as Defendant's Exhibit 5, the same document. So as I stated earlier, there's over 100 corporations named Amazon, variations of the same. And since we didn't know which Amazon Inc. we should be serving, we took the two most popular service addresses, which is the Seattle and the Olympia one. We served the Olympia one. And of course, when you serve, as the judge probably knows, you don't know that that's perfected service until you get an answer. That could not have been perfected service. We don't know. We served the corporation in Tumwater. Then I chose to cover all bases to serve the other most popular registered agent for Amazon corporations. Again, there's over 120 of them in Seattle. When we went to Seattle, my process server was handed this piece of paper that says service on Amazon.com. And at that point, we then knew we had actually perfected service in Tumwater. But until that time, we didn't know that. And so Amazon's position that they aren't responsible for service issues flies in the face of the law. I mean, the plaintiff has to protect their claim and any reasonable steps necessary to protect service. In this case, we never got an answer from Amazon. And I requested several times prior to filing suit for Amazon to provide me the information, which was never provided. So I think the double service is reasonable in this situation with the overwhelming number of Amazon corporations listed in the Secretary of State's website.
So can Miss Alamayu, I'm sorry, Alamayu, can
Mhm.
you tell me where a person would if they were gonna file suit against Amazon and they Google your corporation, or how would they know that it's the Tumwater location?
That's Amazon's registered agent. So in order to sue a corporation, you serve their registered agent, which
But how would she find out that, like, just a lay person? Is it on your website? Is it something she has to Google?
I can check, but I think that that's public knowledge. In California state, for example, they provide, they give that out to people who are filing small claims if they request it. There are numerous ways to find this information, and the plaintiff, well, I guess we could ask the plaintiff how she found the information in the first place. So, because she was able to find that that was the service address. She did properly serve us to begin with, so we could ask
Right.
her how she found it. I
Miss
do
Bloom,
believe it's at, just quickly, sorry. I do believe it is in our conditions of use, our service address. It says at the bottom of our conditions of use, how to serve a subpoena or other legal process. I can share my screen if you'd like to see it, but it has the exact address, 300 Deschutes
okay.
Way, Southwest in
All right.
Tumwater,
And Miss
Washington.
Bloom, how did you did say that you served them and then you just weren't sure because you didn't get an answer. But your process server did actually serve and got personally served an agent, correct?
That's correct,
At the
Your Honor, but
Tumwater location?
right, and the issue that we had was it's not okay. So the registered agent, I went to the Secretary of State's website, which is where you need, yeah, obviously the registered agent is. So I found Amazon.com Inc. I found Amazon Inc. So because I didn't know which Amazon I should be suing, I proceeded to serve both Amazons. One is in Seattle, one is in Olympia. I still don't know to this day which Amazon Inc. is correct. Obviously, I know now because we serve the corporation, service, and company. But because there are different Amazon Incs. registered with the Secretary of State's office with different registered agents, I felt it was necessary to make sure that we were serving the proper Amazon.
Both of the places you served were listed as registered agents.
For different Amazon corporations, that's correct.
Okay, so, all right. And if there's nothing else, I'm ready to rule. Does either side have any closing remarks?
Yeah,
I do. Oh,
sorry,
go
can I just
go
speak
ahead.
and then you can have the last word on this?
Sure.
Yeah,
So
Petitioner,
I would also just like to, sorry, what did you say?
go ahead.
Okay. I would also just like to note that Miss Bloom is an attorney, so she's experienced and she's not a lay person in this respect. She's an attorney. She has experience with making service attempts. If Miss Bloom were to serve every single Amazon location, we wouldn't be held liable for each attempt at service because she thought that those were potential places where Amazon could be served. I don't think that that's reasonable. Like I said, the registered agent is specifically and clearly stated as that address in the Amazon conditions of use. And we were served properly. There was completion of personal service as stated by her own agent. And yeah, I just like to reiterate that we don't believe we owe her any additional damages related to her lost time or inconvenience in this matter. That our damages are limited to what was requested on the complaint and what we were served with and what we came here prepared to defend against. And that's the $374.30 if the court rules in plaintiff's favor, that is the most that they should rule for. And that's all I have. Thank you.
All right, I will let you have the last word, Miss Bloom.
I'm not going to address the service issue, Your Honor. I'm going to address the issue that defense keeps bringing up. First of all, this is not the first time I've told them that I would be claiming wage loss and inconvenience. I've told them before filing suit, and in January when we had a partial hearing with Judge, the who then recused himself. I addressed it there. The pleadings are notice pleadings in the state of Washington, especially for tort cases. I do not have to allege every single damage that I'm going to be claiming. That's what the discovery process is for. Amazon could have at any point asked for me to explain what my damages were. I have put them on notice of the damages. I have told them both, I think, in writing and verbally, that I'll be asking for compensation other than what was on the small claims court. Again, this is a notice pleading state, and I do not have the legal obligation to put down every dollar amount that I'm going to be asking for in a court hearing. It just doesn't work that way. Other states do. I get that. I'm licensed in Oregon, and I have to do that in Oregon, but I don't have to do that in Washington. And the pattern jury instructions are very clear on what I can ask for and what I can't ask for in a tort claim. And this is a tort claim. It's a negligence claim, and I'm entitled to the damages that the law allows me to be compensated for. It's as simple as that. And if Amazon wanted to clarify that, they had 6 months to do it, and they've never asked me for any additional information to document any kind of damages. So it is a notice pleading state.
All right. I'm going to award the plaintiff the following amounts. The principal amount of $374.30. Service $336.10. The filing fee of $52. And you did not appear in court other than today on this case, is that correct?
No, that's not correct, Your Honor. We were in court for almost 2.5 hours on January 26th. We both showed up at 8:30 and were dismissed at 10 when Judge, who was the judge, recused himself because I am a local attorney. It was Judge Sam, I apologize, Your Honor. Myers, thank you, Your Honor. So we were there for 2.5 hours.
Let me see. On January 26th.
That's
and
correct.
The time here, were you on Zoom?
Yes, Your Honor.
Okay, and the judge didn't actually hear the hearing. You were in like the waiting room or in court waiting to be heard?
Yes, Your Honor.
What time did we start this hearing today? Did I come out?
You came out about 9:30, Your Honor, but we're told to be online at 8:30.
32:10. And then did you participate in mediation this morning?
No, Your Honor.
All right. And I don't have anything, you didn't file anything, Ms. Bloom, that would substantiate your $400 rate, any kind of documentation for that, is that correct?
That's correct,
Not
Your
mi-
Honor.
Okay,
That's the rate in my contract.
but I don't have the contract, right? You didn't file that?
I did not, Your Honor.
All right, I'm not gonna award any wage loss at this time. I have no way of documenting what your hourly rate is. If you wish to appeal my ruling or file a motion to reconsider, you're welcome to do that. But at this time, the only information I have before the court is the $374, the $52 filing fee, and the $336.10 for service. So that's the total amount of the award to the plaintiff. And I'll add that up.
And the court is not going to take into consideration the general damages allowed?
I'm not awarding any at this time. I don't have any proof of wages, and I don't, I just don't believe at this time that I'm gonna make that award. 1098.50. 36, that can't be right. Hold on, I'm just trying to do the math here. 374.3, 52, 336.1. $762. Do you have a whiteout? $762.40 to the plaintiff. I'm not giving an award for inconvenience or lost wages or general damages at this time. 762.40. That'll be the order of the court.
Thank you, Your Honor.
You're welcome. Thank you both.
Thank you. Have a good one.